Ladies and gentlemen, I have been asked to explain to you in the next minutes some points on the Qualification Directive, and more in particular to give you an overview of the specific safeguards that the European Parliament managed to insert in this instrument during the negotiations. Allow me also to stress that what I'm going to tell you are my personal views, and they are not by any means linked to the views by my institution. I will give you an overview of those achievements which are related to several points of the Qualification Directive. Allow me just to introduce this instrument to you as the first one that was agreed between the two co-legislators after the first generation of asylum law, which was done by Council alone, and where Parliament had only been consulted. Due to an article in the treaties, after the 1st of December 2005, the new generation of asylum law would have to be set in place under the co-decision procedure, and therefore this instrument has been a trendsetter first of all on concepts that would be repeated also or be valid also in other instruments such as the Dublin Regulation or the Reception Conditions Directive, or also it is a first instrument where the negotiating techniques and the trust among the two institutions was tested, as in this area of asylum, which is very closely linked to the sovereignty area of the national administrations. The negotiations were quite prudent from both sides and also very, very difficult. Anyhow, after the orientation vote that put together the position of the Civil Liberties Committee in the Parliament, this orientation vote that happened on the 1st of February in 2011, 6 trilogues have taken place. And during those trilogues, all the points were discussed between the representatives of the Council, representatives of the Commission, and in the Parliament, the negotiating team, which is composed by the rapporteur, which was Mrs. Lambert, and 6 shadow rapporteurs, which represent the 6 other groups of the political spectrum in the Parliament. This negotiating team has been fighting for some of the core values of their institution, and we will now slowly go through them. The aim of the directive was clearly to approximate the rights of the 2 categories which figured in the former directive, which were the refugees, so the ones that had the beneficiaries that had refugee status, and the beneficiaries of subsidiary protection. This aim was achieved for access to employment and employment-related education opportunities, access to healthcare, and access to integration facilities. For the validity of residence permit and access to social welfare, some differentiation remained. For the validity of the residence permit, there is the problem that for beneficiaries of subsidiary protection, the member states had a lot of difficulties to allow for a first residence permit of more than 1 year. So, even after having tried a lot, the Parliament managed to get a first residence permit for those beneficiaries of subsidiary protection of 1 year. And eventually managed as well that in case of renewal after that 1 year, the next residence permit had to be at least of 2 years. You all know that for refugees, the residence, the initial residence permit is going to be valid at least for 3 years. In the area of social welfare, there is still the possibility for member states, so it's not an obligation, but a possibility to limit the social welfare to core benefits. This was indeed already the case in the former directive. And in the former directive, there was also a recital that gave an understanding of what core benefits means. Member states, however, in the negotiations didn't really want to refer what was to the content of those core benefits, but for them it was enough to refer to the core benefits allocated to nationals. The European Parliament insisted on having a common understanding as to what core benefits for social welfare mean, because we are and were aiming of having a common European asylum system, and therefore it was also very important to keep then recital 45 in place, which says that the core benefits must be understood as covering at least minimum income support, assistance in case of illness or pregnancy, and parental assistance. So you see that if Parliament would not have stood for a common understanding, there would have been only a reference to core benefits without further specification. A second very important point for Parliament is the best interest of the child. And this was first reflected, we think, in the definition of the family members. The initial definition of family members in the Commission proposal was quite extended, and it included also married minor children of the beneficiaries or of the couple. But married minor children, member states were absolutely not in favor to include them as family members of the core family, because once they're married to minors, they are not part anymore of the family. That is their reasoning. Apart from this, we also lost the reference which was in the Commission proposal, the reference to siblings as being part of the family members. This was also a non-go. However, we managed in Parliament to insert recital 39. And in recital 39, it is clearly stated that in exceptional circumstances where the close relative of the beneficiary of international protection is a married minor, but not accompanied by his or her spouse, this is very important, not accompanied by the spouse, the best interest of the minor may be seen to lie with his or her original family. So you see, in exceptional circumstances, especially when the spouse is not present, there is a possibility that they are anyway part of the core family. In that same recital, so at recital 39, there is also a reference to particular circumstances of dependency on the beneficiary of international protection of close relatives who are present in the member states and who are not family members in the sense of the strict definition or narrow definition we then eventually got in the Qualification Directive. So if you have questions about the family definition, please look also at recital 38 so that you can understand what are the possibilities to interpret this maybe narrow or initially, when you look at it, initially narrow definition. And also do not forget that in the review clause there is a particular reference to Article 2. So what are family members, it's a work in progress, because in Article 38, first paragraph, which is the review clause, when the Commission does its reporting on the application of the directive, it should really give particular attention to this definition of family members, in order to assess if there is a need to adapt, to change it. The best interest of the child was also, as a concept, very much debated during the negotiations, as the Parliament initially would have liked to have a definition of what indeed is the best interest of the child. This amendment initially went as follows. The best interest of the child shall be established by reference to the UN Convention on the Rights of the Child and the recommendations, concluding observations and reports of the UN Committee of the Rights of the Child and other UN agencies. However, it is clear that really to give a definition of what is the best interest of the child, it's very difficult, as it is really generally relying on a case-by-case basis. And therefore, as a compromise, the Parliament obtained recital 18, where it is stated that in assessing the best interest of the child, Member States should in particular take due account of, and so the Parliament has not got a definition, but has listed a series of points that are important to assess the best interest of the child, and those points are the principle of family unity, the minor's well-being and social development, safety and security considerations, and eventually the views of the child, of the minor, in accordance with his or her age and maturity. So this is what we eventually achieved. The next point is on actors of protection. Article 7 is explaining that actors of protection can be or the state or parties or organizations controlling the state or a substantial part of the territory of the state. In Parliament, there was a general objection to this letter B. The Parliament didn't want to be parties or organizations to be considered as protectors. However, this was very difficult. A very difficult position. First of all, because politically the Council would not easily accept, and secondly, because of this letter B was part of a wide area in the recast. As you know, the Commission proposal for this review of the first generation of the Qualification Directive was done under the form of a recast. A recast aims at producing, at the end of the co-decision exercise, the full text integrally again, so that when you read the new text, you have immediately access at the full edition. This is much more kind for the end user. But as the Commission is the one to have the right of initiative for new proposals, they indicate as from the start which parts they allow for amendments, and those parts are colored in or highlighted in grey. In Article 7, paragraph 1, letter B was not highlighted in grey but in white, which means that the Commission proposal didn't offer the possibility, or technically not offer the possibility for amendments. However, the Parliament obtained some points in this article. First of all, if you read the first sentence of the first paragraph of Article 7, you see that there is written protection against persecution or serious harm can only be provided by, and then the states or the organizations. This little word only was very much contested by the Council. But during the negotiations, the Parliament managed to keep it in order to keep the list of actors of protection limited and exhaustive. The deletion of this word would have led to a non-exhaustive list. A second point that the Parliament obtained was that the last part of the first paragraph, provided that they are willing and able to offer protection in accordance with paragraph 2, was relating and to the state and to parties and organizations. So this means that in the original Commission proposal, this very small sentence was only linked to part B. So parties could be actors of protection if they were willing to. Now in the new text, it's also the state can only be an actor of protection if the state is willing and able to offer protection, which absolutely widens the scope. And a third point to comment on this article, it is that Article 7, as it was so important for the Parliament, is again inserted in the review clause, which then will oblige the Commission to focus particularly on this article when it is reporting on the application of the directive. Article 8 is the next article, and this is about the internal protection, so the internal flight alternative. The Parliament had an amendment which said that a person can be expected to look for protection in its own country when he or she can travel and live in that part of the country without risk or penalty. After negotiations, this part became, and you can read it in the last part of Article 8, first paragraph. So, internal protection can be considered when the person can safely and legally travel and gain admittance to that part of the country and can reasonably be expected to settle there. In the proposal of the Commission, it was only written and can settle there. So now we have a little bit a more prudent, let's say, definition. The person must be reasonably expected to settle there. On that part, allow me also to draw your attention to recital 27, where you can see that it is added that where the state or agents of the state are the actors of prosecution or serious harm, there should be a presumption that effective protection is not available to the applicant in the same country. So we have this specific addition that creates a kind of presumption that once you have a state actor of persecution, it's not so sure that the person concerned will find easily an internal flight alternative. And also there is an addition we managed to insert that for unaccompanied minors, the availability of appropriate care and custodial arrangements, which are in the best interest of the unaccompanied minor, should form a part of the assessment as to whether that protection within the country of origin is effective. I now come to the last part of this presentation, which relates to the integration programs. The Parliament was convinced that language training is really a key element of integration, and therefore it had inserted this element in Article 34. Article 34, which relates to access to integration facilities. Actually, it was not the Parliament that inserted the reference there to language training, but the Commission in its recast proposal. Member States, however, found that the first paragraph, which is now the entire Article 34, was already the statement of a big principle, and that there was no differentiation necessary, so as having examples in the second paragraph, because the Council explained that that we could not put standards just by listing examples, and therefore the Parliament was using again the recitals to put or to express very explicitly the need for language training, or the key need or the key importance of language training. And you will see this in recital 47, which says that integration programs to be provided to beneficiaries of international protection, including, where appropriate, language training and the provision of information concerning individual rights and obligations relating to their protection status in the member state concerned. So in this way, the language training regained its place in the directive. A last point of the integration programs could be Article 28, which relates to the recognition of qualifications. In Article 28, as for now, there is no reference to the deleted Commission proposal, the third paragraph, which said that Member States shall endeavour to ensure that beneficiaries of international protection are not prevented from seeking either recognition of their foreign diplomas or accreditation of their prior learning because of the costs involved. The Member States really did not want to accept this wording because they found it too specific, and they also said that it was the cost for such a provision would be very high when it had to be implemented. But they then in place accepted to make Article 28, second paragraph, more strong. And now it says that Member States shall endeavour to facilitate full access for beneficiaries of international protection to appropriate schemes for assessment, validation and accreditation of their prior learning. So this the word full access was, as Member States explained, the specific guarantee that indeed the Member States were not allowed to introduce excessive cost for recognition of qualifications in third countries. This loss of this reference to cost was partially recovered in recital 42. In recital 42, where again it is highlighted that efforts should be made, in particular to address problems which prevent beneficiaries of international protections from having effective access to employment-related educational opportunities and vocational training, inter alia, relating to financial constraints. And so, indirectly, here again, it is stated that by the inter alia, that any kind of constraints should be avoided, and that when it is said in the directive that access to some rights are guaranteed, it should be a full access, and certainly also not an access which is reduced due to cost or other elements. I think by now I have arrived at the end of the achievements, and I want to thank you for your attention.